Section 8, Maintenance, Possession, and Compliance with the Laws. Exhibit TRLI 2001B, Equipment and Lease Agreement for Hopper and Railroad Cars. Section 8.1, Maintenance and Operation, and as the lessor as at its own cost, expense shall maintain and repair and keep each unit and cause the manager under the manager agreement to maintain and repair each unit according to prudent industry practices in all material respects and good working order and good physical condition for railway cars. For similar age usage, normal wear and tear expected to in manner in all materials respect and consistent with the material practices used by the manager or with respect to any equipment subject to an existing equipment sublease is a net sublease. The applicable sublease is applicable or the applicable sublessor is applicable in a respective railway cars and managed by the manager or within the respect of any of the equipment subject to an existing equipment subleases that in the net sublease the applicable sublessor is applicable similar in type of the such unit is 3. In accordance with all material specs of the manufacturer's guarantees and effect accordance with applicable provisions if any insurance policy required for the be maintained pursuant to section 12 and 4 in compliance with all material specs and applicable laws, regulations from time to time in effect, including without limitations to the field manuals of AAR and the Federal Railroad Administration rules, regulations, interchangeable rules as they apply to the maintenance operation units, and they interchangeable regardless of upon such applicable law regulations nominally imposed provided, however, so long as the manager or with respect to the equipment subject to the existing equipment sublease is applicable to the sublessor as applicable is similar contesting with such all regulation with respect to all other similar equipment owned and operated by the manager with respect to the equipment subject to the existing equipment sublease is the applicable sublessor is applicable to the lessor in good faith and appropriate proceedings diligently in conducting contest validation and application of such standard ruling of regulations in any responsible manner with it does not materially interfere with the use of possession, operation, and returning of any of the units materially advisedly affects for the right of the interest to the leaser and indenture trustees of the units here under the otherwise exposed leaser and indenture trustee or in participation of criminal sanctions release of the lesser of the obligation returned to the units in compliance with the provisions in section 6.2 provided that the further the lesser should properly notify the leaser and identify trust and indenture trustees as a responsible detail of any such concept if no event shall lease the discrimination in any material respect as to the maintenance of any other unit, including the periodically maintenance and recording in respect of such unit as compared to the equal of the similar nature of the manager's own to manage. The lesser will maintain in all respects all records, logs, and other materials require relevant industry standards, governmental authority, and having jurisdiction of the units required to maintain in the respect of any of the unit as all as if the lesser is owner of such units, regardless of whether they are any of such requirements by their terms are normally imposed on the lesser to the leaser and the owner of the participant. B. With written and waiver and consent of the leaser, which with the waiver consents with unreasonable withheld, the lesser shall not change or permit to a sublease. The lesser shall not change or permit any sublessors to change the .AAR classification also provided in Chapter 49 CFR of the Part 179 and any successor thereto to permit the sublessors to appropriate any of the unit different of the .AAR classification of the classification in effect of such unit of the closing day except for any change in the test pressure rating provided that the changes do not increase the pressure rating of the unit above the tank test pressure to which the unit was manufactured, provided however that in the event of the lesser shall not be provided with the lease in the event of the leaser shall not provide the lesser with a written business days after receipt of the lesser's written request. Therefore, the leaser expressly rejects such request of the lesser may also elect to replace a unit in accordance with the subject of provision of sections 11.2, 1, 11.3, and 11.4. Sections 8.2 possession and use lease and shall be entitled to, the lesser shall be entitled to the possession of the units of units in the affiliated of the United States are subject to the remainder of the provisions of Section 8.2, Section 8.3, Canada and Mexico only in the manner for which it is designed and intended so it is subject and only in ordinary wear and tear, if no business shall lease in each store the permit. The use of storage of any unit in any jurisdiction, not including the current insurance coverage where it is required under Section 12, the unit shall be primarily domestic routes in the United States, if no event shall more than 50% shall more than 40% of the units or other units as determined by the mileage records measured annually of the calendar year basis be outside of the contiguous in the United States. At the same time, nothing in the Section 8.2 shall deem to constitute permission of the leaser to any of the person that acquires the possession of any of the unit and take any action inconsistent with the terms and provisions of the lease and operative agreement. Section 8.3, the sublease of the lesser. So the lesser shall be entitled, without the prior approval of the leaser, to enter into a sublease, a car contract, or other contract granting a permission for the use of the unit. A railroad company and companies that is not credit of the bankrupt Trinity or affiliated Trinity organized of the laws of the United States of America state, therefore the District of Columbia, Canada, and any province of the Mexico state, therefore of the lines of the railroad will or be operated by such railroad company of the companies that over with such railroad companies and the companies have tracked its rights of the operation of their trains and upon the connection right of their own careers, the usual interchanging traffic. 2. Responsible companies, i.e. the company in which the manager would do the business in ordinary courses of the business with respect to the rail cars to its own manages other road companies, Trinity affiliates, and Trinity of the credit bankrupts for the use of their business. 3. The whole subsidiary of the Trinities organized of the law X of the Canada, the political subdivisions thereof, the each a Canadian affiliate, Y Mexico political subdivision, each a Mexican affiliate. Subleases to any of the subleases referred to the clause of 1, 2, and 3 in the Section 8.3 have been referred to the permitted subleases, provided, however, the lesser shall not a sublease to a sublessor organized under the law of Mexico any of the state of the Mexican subleases if after the given effect of the sublease the percent of the units the other units pledged in the units the aggregated and measured in the number of the units other than the units pledged units in the not mileage record sublease to the Mexican sublessors excludes the lesser of 7% within the rating of confirmation of 20% of the units over than the units pledged and the units aggregated as to the percentage of the railway cars leased and subleased to the Mexican sublessors and total managed fleet be the sublet more than 50 units other than the units in the single Mexican sublease other than X in the rating agency confirmation of the Mexican affiliated of Mexican sublease with a credit of rating of at least BB or BAA2 is determining the SP and the Moody's respective or other event of either of the SP. Moody's shall not be cease to provide credit rating for such entity or credit rating at least BBB and BAA2 and NP and Moody's in the case may be other than 2 the full unconditional irrevocable guarantee that for such Mexican subleases parent with sublessors parent with the credit rating of at least BBB and BAA2 determined by the SP and Moody's respective. 3. The letter of the credit is provided by the credit rating at least of an A plus or an A1 determined by the SP and the Moody's respective, provided further that the lessor shall not at any time of the sublease more than 20% of the rating agency's confirmation of 30% of the units that the other than units is measured by the number of units and other units not mileage records aggregated in the Canadian affiliates, provided further that any unit sublease to the Canadian affiliate or Mexican affiliate should sublease to the Canadian affiliated Mexican affiliate shall be subleased to the person of the type described in 1 and 2 above the pursuant to subleases containing the terms, any conditions similar in all materials respective to the applicable sublease to maintain between the lessor and the applicable Canadian affiliated Mexican affiliated, provided further that the subleases may provide greater rights of the subleases that provide sublessors in related to subleases. Each sublease is an extended per minute of the lease that, other than the existing equipment subleases, shall include the appropriate provisions so that so much as a sublease shall require the payment of the rent of the dollars in the fair market rented value, not disappropriatedly in the term of the sublease as compared to the later term of the sublease, shall not permit any other subleasing for any other cases of subleasing and any subleasing other than a subleasing Canadian affiliate or Mexican affiliates to the person as described in clauses 1, 2, and 3. 1, 2 in the immediate preceding paragraph, containing the conditions similar in all materials with respect to the applicable subleases between the less or in the applicable Canadian affiliated Mexican affiliated single trip subleases and subleases by permitted subleases as long as such subleases is acts as a term of not more than 1 year. Y, subject to subordinated subleases to the sublessor and on the terms of what would be permitted subleases if it were entered into directly. Partnership shall not be permitted in subleasing provided by the rights of the sublessor to offset otherwise set off against amounts of dues of the lesser for each of the sublessors under the applicable sublease to be permitted in all materials arising under the sublease, except for the sublessors may offset otherwise set off amounts due to the marks of the company tree under the sublease without regarding the payment of the basic rent of the lease term, and this shall not include a term of the provisions which is inconsistent with the term and conditions of the lease, which could reasonably expected to result in material adverse consequences of the lease or any participation in the indentured trust is in being agreed to the sublease. Substantially, it is form of attached Exhibit B1 and B2 satisfies the provision of the sentence 5. If it does not, the term extended 3 years beyond the later of the year 1, the basic expiration to 2, who, if the applicable end date of the renewal term is in effect, the lease will commercially responsibly effort to have subleases other than the existing equipment. 1, provided the sublease all requirements for the sublessor any other person claiming or who may or hereafter claim under the throughout sublessors under the sublease, including any of the purchase options of the sublessor thereunder, they be made subject and subordinate to the terms of the lease, and 2, substantially in the form attached to Exhibit B1 and B2, notwithstanding for the foregoing, in no event shall the lease lesser of any of the affiliates to be required to take any action to perfect any security interest of any of the persons who have a sublease or have any in the sublease and other filling out the UCC financing statement against the partnership in the jurisdiction, and the partnership's chief executive office is located in the partnership jurisdiction, and form information covering all the subleases. Generally, no subleases are entered in the lease. Lessors hereunder shall have the lesser of any of the liability obligation hereunder, which shall remain those in principle and not in surety. Nothing in section 8.3 shall be deemed to constitute permission to any of the person's possession of the unit pursuant to any of the subleases to take action inconsistent with the terms of the provisions of the lease of any of the operative activities or agreements as in used in a section of the 8.3 sublease is noun means a sublease, a car contracted or other car contracting, granting permission for the use of the unit in sublease as a verbal means of entering into the foregoing. Section 9, modifications.